He said his mother was missing, but hours later, police found burned remains in the yard, bones, even part of what looked like a human spine. And now, 20-year-old Nicholas Yates, he's accused of murdering his own mother, Cheryl. And what investigators say he allegedly confessed to is beyond disturbing. We are going to break down the details of this case with an Indiana criminal defense attorney. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. This is an incredibly chilling case, because I want you to imagine someone calling the police to report their mother missing, and then hours later, investigators find burned human remains in the yard. That is exactly what prosecutors say happened in Clinton, Indiana. And now, 20-year-old Nicholas Yates, the very person who made that call, is in custody, charged with murder. And the affidavit in this case, it lays out what police say is a dark, twisted trail of contradictions, lies, a backyard fire. This all started in early October when Yates reported that his mother, Cheryl Yates, was missing. But the story that investigators pieced together from his own statements, witness interviews, physical evidence, it paints an even darker picture. According to the probable cause affidavit, Yates allegedly admitted that he struck his mother during an argument, stashed her body in a wooden box, and spent hours burning it in a backyard fire pit. The document describes, quote, a smoldering pile of papers, bones among the ashes, and one bone, quote, particularly indicative of a human spinal column. Now, we're going to walk you through how investigators moved from a missing person call to a full-blown murder case, and what Yates is now accused of, in his own words. So let's get into this. The case begins back on October 5th. That is when Yates called law enforcement to report that his mother was missing. The affidavit states that deputies arrived at the home in the 300 block of Davis Street in Clinton on October 5th, 2025 at, quote, approximately 5:36 p.m. Vermilion County Deputy John Hawkins was dispatched to 364 Davis Street in Clinton, Indiana, in response to a missing person report. This report had been initiated by Nicholas "Nick" Yates. Now, according to the affidavit, Yates told Deputy Hawkins that he had last seen his mother Cheryl on Friday, October 3rd, and that he had been calling her phone since then. Here's what's weird. Police say he also told them that she had taken all of her clothes, her ID, the bank card, but left behind her purse, her wallet, and her phone. Now, did you catch that? Police say Yates told them that Cheryl left her phone behind, yet he also claimed to have been calling it. I mean, why call a phone that never left the house, right? Well, when asked about that, according to the affidavit, quote, Nick advised that Cheryl had gotten a new phone, but she had kept the same number. Deputy Hawkins then asked to see Cheryl's phone, but Nick advised he had sold it because he needed the money. Now, deputies asked if they could enter the residence. Yates apparently said he'd need to talk to two people that he asked to move in, saying that they would need to know what was going on. And when pressed whether he knew of anyone who would want to harm his mother, Yates responded, no, she was the sweetest person. Inside the house, deputies, they noticed that Cheryl's pill planner, her medication, was taken the morning of October 3rd, but not afterward. Outside, deputies find this, quote, smoldering pile of papers near a burn pile. According to the affidavit, Yates told them he had burned DCS papers belonging to his mother because he didn't want to get in trouble for having confidential information while she wasn't there. But as investigators dug deeper, that is when they made a gruesome discovery. The affidavit reads, we proceeded to the backyard where we discovered bones within the burn pit. The shape and appearance of the bones would lead one to believe that they perhaps were human bones. Particularly indicative of a human bone was one bone which appeared to be that of a human spinal cord. So after being read his rights, Yates apparently initially denied any involvement, but as the interview continued, that is when his story reportedly began to shift. We are going to get to that in a moment. But first, to help me break all of this down, I want to welcome back here to Sidebar Indiana criminal defense attorney Andrew Baldwin. Andrew, thank you so much for taking the time. Appreciate it.
See you, Jesse.
How would you approach a case where you have this accused who initially reports a missing person, but then allegedly provides inconsistent statements to police? This is, again, the allegation that Yates did with his mother's whereabouts and phone. How would you approach a case like that?
Well, I find that these cases, and this may be shocking to some people, are actually some of the more easy cases to strategize about, because you're working with a pile of dog poop here at the beginning, and you're trying to how do I polish this? How can I extricate my client from this? And I've actually had cases with burned bodies a couple of times. And so here's what I would do. I'd ask for a speedy trial. I think that in Indiana, that's 70 days. In most states, that's 70 days. You do not want to give the state an opportunity to start taking the bones to wherever they would take them to start studying to see if what Nick, the accused, said is even accurate. Because ultimately, the defense here is not that difficult. It's something other than murder. What he details in his confession, if you want to call it that, is that he got upset at his mom, and in the heat of the moment, he struck her. And then after striking her, she fell and injured herself. And it's not that crazy that somebody that is so concerned about being thought of as a murderer, even though it was more of an accident following a battery, that person does the things that he did, takes the body, tries to burn it. I mean, I'm not saying that that's a normal reaction. Okay?
I know.
I want that understood, but I'm saying it's at least arguable to a jury. And you do not want the prosecutor to have that much time to kind of think this thing through. So speedy trial.
That's an interesting perspective. Because I was going to ask you, when you're dealing with a burn pile, when you're dealing with bones, what kind of testing would the defense do on this? Or would you just say, hey, listen, let's own up to it, right? Let's own up to the burning. There's nothing more to look here, but you're concerned that if you get into the weeds with testing, your experts, the prosecution's experts, then they could get a little bit into, well, we can tell what kind of wound this was. We can tell maybe a series of events. That's what you're saying, right? That's what we're talking about testing.
Right. Now, I don't know the condition of those bones or if there's a skull, because it sounds like he's trying to claim that the skull hit a wooden crate or something, and that's what caused ultimately her death. And if the skull's around, you definitely don't want to give them time to test the skull, and that then they could say, well, his story's not adding up with the evidence that we see.
Right. By the way, you know why we're able to bring you stories like this? It's not only because of the amazing support that we get from all of you out there, but also from our incredible sponsor, Morgan & Morgan, America's largest injury law firm, a firm with over 1,000 attorneys. You know why they're so big? Because they win a lot. They have recovered over $25 billion for more than 500,000 clients. In fact, in the past few months, a client in Florida received $12 million after the insurance company offered just $350,000. Out in Pennsylvania, a client was awarded $26 million. That is 40 times the insurer's $650,000 offer. You have another client in Pennsylvania who received $29 million after being offered only $500,000. And even if you think that your case isn't worth millions of dollars, why not start a claim and fight for what you deserve? Morgan & Morgan makes it so simple. You can start a claim from your phone in just 8 clicks. So if you're injured, you can easily start a claim at forthepeople.com/LC Sidebar by clicking the link below or scanning the QR code on screen. Okay, so let's get into this. This probable cause affidavit lays out, in what I will say is chilling detail, how investigators say Yates' story began to unravel almost immediately. Because after police discovered what they say are human bones, Yates was read his rights, and he initially claimed he hadn't seen Cheryl in a month. Police say that Yates also showed them an app that displayed Cheryl's last known location at a bingo hall, and that this was on October 3rd. But when pressed further, Yates admitted it was actually him at the bingo hall, that he was using his mother's cell phone. Apparently told deputies he was there with friends, later sold her phone at a Kroger kiosk. And remember this version of the story because later we're going to revisit the timeline from the accounts of other people who appear to contradict what Yates said. So, Andrew, going back to this, do you immediately accept that this is, like you said, a confession, or what are the common legal strategies for challenging or contextualizing what a defendant says? And as you and I both know, this is why a suspect, a defendant, usually retains counsel and doesn't say anything because you don't want to have to clean up everything afterwards. But how do you challenge it?
Yeah, Jerry Spence, one of the most famous criminal defense lawyers in the country, always said, when you are explaining, you are losing. And you always have to explain away or try to your client if they've said things. So the first thing you try to do is get the confession tossed, get it thrown out. There is a little window here from reading the probable cause affidavit. I don't think it works, but if you're not going to file a speedy, it would be worth going down this road. And that is, in Indiana, we have these things called Purtle rights, and that is, before you go into somebody's house, before you go into somebody's car, you have to let the person know that you don't have to let me into your house. You do not have to let me into your car. And I just had a case 2 weeks ago that the judge tossed the major pieces of evidence because of violation of PERDL. Well, what is it? If you are in custody, and this is where they probably lose, but if you are in custody, they are required to read you your PERDL rights before you walk into the house. Well, in this case, like you just said, Jesse, they were talking to him and the police realized that his story was inconsistent. And in fact, I would say that he committed a crime right in their presence. He committed a misdemeanor in that he lied to the police. It could be obstruction of justice. And that was from when he said, my mom was at the bingo hall. Okay, no, I was at the bingo hall. Well, now he's lied. And now the legal argument from the defendant would be, now you know that he's committed a crime, yet you should be reading him his rights right then. And then you didn't read him his PERDL rights right after that. And then you asked him permission to go into his house. Everything once they go into the house, including looking at the burn pile, all of that evidence should be tossed. You might want to go down that road, and you might want to use that certainly as leverage if you can try to convince the prosecutor that we're going to win on this. So why don't we get this knocked down to a voluntary manslaughter or a reckless homicide and avoid all the drama of a trial and the time.
Because a lot of this is bad evidence. I mean, previously mentioned that investigators actually made a specific note of when they were questioning Yates, because when police asked whether anyone might want to harm Cheryl, Yates responded, no, she was the sweetest person. But according to the affidavit, officers emphasized the way that Yates used the word was, that was a red flag. So this is why Andrew and I are talking about what our avenues defense could explore here, since this could be a really problematic case for them. Well, after hours of questioning, Yates allegedly admitted what happened, that he told police that the two had argued on October 3rd after Cheryl told him to either move out or she would. And for context on what that argument might have been about, according to the affidavit, Sheriff Mike Holtkamp spoke with Cheryl's supervisor at her workplace, Robert, who advised he had seen Cheryl leave work on Friday, October 3rd at approximately 2:30 p.m. Further conversation with Robert revealed Cheryl had her cell phone with her, and she had made a comment while at work stating she was going to kill him, referring to Nick, when she got home. According to Robert, Cheryl had said that Nick has been spending all of his money and Cheryl has been paying all of his bills. Well, after this apparent argument, police say that Yates told them in detail what he reportedly did to his mother, and we will get to that first. But Andrew, back to you. You have this cases, police report that an argument may have triggered an alleged crime. How do we evaluate these claims from coworkers or friends, family members, talking about what the victim may have said about her relationship, any clues about what may come, talking about that family dynamic? I'm assuming these will be essential witnesses at a trial. From a defense perspective, how do we view these witnesses?
Well, I think I'm going to kill my son probably said in jest, like parents say about their kid who gets arrested or is dating somebody they don't like. I'm going to kill him. It's probably that, and that's I don't know what they don't talk about in the PCA, the tone. But I could make that a centerpiece in a way of the defense, because it's all of a sudden, if you're talking about heat of passion, trying to get that murder knocked down to a voluntary manslaughter or a reckless homicide, then now you have a piece of evidence that's like, we know that she was angry at him, and we know that therefore an argument started, and that's where the heat of passion comes in. And so I think that could be central. Now, you might have some evidentiary issues. Is it hearsay? The mom is dead. She's no longer able to come in and testify. Yeah, that's what I told my coworker. And the coworker saying in court, that's trying to prove the truth of the matter asserted, as they say, what hearsay is. And so they might try to keep that out. So there could be some pretrial motions to keep those types of testimony out.
So let's talk about what happened next. Police say that Yates, in a chilling fashion, confessed to killing his mother. The affidavit reads, he stated he struck his mother in the throat and her face turned blue. During the confrontation, she fell backward, hitting the back of her head against the metal bed frame, and then fell to the right, impacting her head on a large wooden chest. Investigators say that Yates told them that Cheryl was silent after collapsing, that he allegedly placed her in a wooden box, left her there overnight, and then the next day, on October 4th, rolled that box out to the backyard fire pit and set it ablaze. The affidavit reads, he placed his mother into the burn pit with her still inside the wooden box and used doors that they had repurposed as a privacy fence to burn his mother. Mr. Yates claimed that he maintained the fire for most of the day on Saturday. Now, meanwhile, the two people who had recently moved into that house, they told police a very different story, and we're going to get into those details in a minute. But Andrew, I always wonder, how do prosecutors, how do investigators, do they just take all of this as true? I mean, this is very specific, what allegedly happened. You also take it with, my gosh, this is what the suspect is allegedly saying. Do they take it all as true? Do they corroborate it? If he's admitting to such specificity, does it have to be true? Talk to me about that.
Well, they better not just take it as true, because I'm going to tell you what I do as a defense lawyer. If they don't DNA swab that chest or whatever they called it and the bed frame, or look at it to see if there's, some spots of blood, they don't run a serology on those areas and the floor and everywhere else to see if what his story is, whether it's consistent or not. Because, again, I'm going for voluntary manslaughter or reckless homicide, and if his story ends up holding up as true, then you might have a legitimate shot at getting that type of verdict. But if you police officers, law enforcement aren't doing those things, then boy, we take advantage of that on the defense side. You didn't do this, did you? You should have done that, shouldn't you? And it was a mistake, and the jury deserved to hear that type of testimony. And you try to rile up the jury about an improper investigation if you can, if it's possible.
Right. So let's go back to these two people who had recently moved in. Well, earlier I mentioned that police say Yates told them that he was with friends at a Kroger kiosk selling his mother's phone on October 3rd. But according to the affidavit, these two people said they never went with Yates to a Kroger kiosk, that he spent the day after Cheryl's disappearance cleaning, including washing her bed sheets, shopping, paying for most of the items with cash. WTHR also reports that later on, the friends told investigators that Yates had called them back on September 30th saying his mom was, quote, moving out, and that he needed to know by October 3rd if they wanted to move in. Now, Andrew, you and I have been talking about possibility of this being manslaughter versus a murder, right? Does these kind of details complicate it? I have seen cases before where somebody looks so bad. They went to all these lengths to clean up the crime scene, make sure they didn't get caught. It doesn't necessarily mean that they cold-blooded murdered somebody. It could have been someone died under other circumstances. They hid the body and panicked. It could be a manslaughter. But it does raise a lot of questions about the sadistic nature of these allegations, right? If someone is able to do this and cover this up regarding his own mother, is it a stretch for a jury to believe, wait a second, I'm believing this guy, if he can do this, maybe he really did murder his mother and it was not just a heat of the moment kind of thing.
Yeah, I think it is very hurtful that he's out spending money and you get this image in your mind of this punk, lazy kid that's in this house, and the way I'd paint it as prosecutor, perhaps. And as soon as she dies, is he crying about this accident that happened after a heat of passion moment? Is he upset? What is he doing? No, he's bringing in these two people, and he's going out and buying them dinners and things like that. It doesn't paint a great picture for Nick that he's out, again, spending money, kind of lavishing his two friends that he then brings in. I mean, it almost looks like a plan. Like, if my mom doesn't leave, because the mom said she was going to leave and he didn't want to be there alone. If my mom doesn't leave, then I'm going to kill her. And then I'm going to take her money and I'm going to lavish it on my friends that I'm moving in. And it makes that the voluntary manslaughter argument, heat of passion argument, makes it very, very difficult. Just another landmine you're going to have to figure out how to dodge at trial.
By the way, is this a case where he would have to testify to explain this stuff?
Larry Posner's the king of cross-exam and trial tactics, and he never wants to put his client on the stand. I don't agree with him necessarily, but this is not a case where I can imagine that I'd want to put this guy on the stand. I mean, he's already kind of sunk his boat in the things that he has said to police, and I don't think he could probably, you try. It's his choice, his constitutional choice, and you work with every client that I have go to trial, we work with in the event that they're going to testify, but I cannot imagine it would be a good idea.
Legal question for you, because on October 7th, prosecutors officially charged him with 1 count of felony murder. He pleaded not guilty. He's being held without bond, and the court records show he's due back in court in January for a pretrial conference, a jury trial set for February. Why felony murder?
Well, felony murder, we defense lawyers hate because it's in the commission of a felony, somebody dies. And if somebody dies in the commission of a felony, whether you intended to kill them or did not intend to kill them doesn't matter. It's still felony murder. So it's kind of a workaround for prosecutors when they fear that they're not going to be able to prove intent. I'm not really sure what the felony they think he committed is. So that would be something normally.
But it could be like assault or something like that, right? Aggravated assault.
It could be, but that could be an underlying. That also, from a legal perspective, could be part of an underlying element of the crime, and therefore maybe not. You can't use felony murder for that, perhaps. But commonly, just so that everybody out there knows, it's like if you're the wheelman in an armed robbery, and nobody expected anybody to die, and somebody dies, and you had nothing to do with it. That's felony murder. That's the classic example.
Or if you kidnap somebody and let's say you put them in a box to hide them and they die, you might not have intended for them, but in the commission of a kidnapping, they die. It's like it's felony murder. This idea of a trial being set for February feels kind of quick. You mentioned speedy trial. Do you think that's, first of all, is that timeline right? Do you think it'll actually stay for February?
Probably not. Most lawyers won't pull the trigger on a speedy trial just because they're not equipped typically to try it that fast. But I got to tell you something, on a case like this, you got to swing for the fences. Yeah. You got to disrupt the prosecutor's rhythm, and a speedy trial, that's the way to do it. I mean, it's easy to Monday morning quarterback, or I guess would be actually Saturday morning quarterbacking, but that might be a way to disrupt the prosecutor's rhythm and also get them to start thinking about, man, I'm not going to be ready as a prosecutor, and I don't want to release him, because that's one of the remedies for the prosecutor not being ready in 70 days is releasing the defendant. And so it could lend itself to, hey, I'm a prosecutor. I'm not going to be ready. Yeah, I'm ready to talk voluntary manslaughter. I am. Now, these are all unlikely things. I mean, more than likely, the prosecutor, this is a big case. It's getting coverage. They're going to be able to try this case in 70 days. Yet, that might be on the defense side the very smart move to make.
This is a very disturbing case. Feels like a tough case for defense attorneys given this alleged evidence, but I appreciate you breaking it all down, trying to think about ways that this might go. Andrew Baldwin, always love having you on. Thank you.
Great to see you, Jesse. Thank you.
But that is all we have for you right now here on Sidebar. Everybody, thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you get your podcasts. You can follow me on X or Instagram. I'm Jesse Weber. I'll speak to you next time.